Hello, I'm Hank Fastic with the Supreme Court in My Hometown program, and I was wondering if you could give a brief description of your connection to the Cathy Kuhlmeier v. Hazelwood case.
Okay, well, I was a law clerk for Judge Nangle from 1983 to 1985, and during my tenure as a law clerk, the case was tried. It was a non-jury civil case, obviously, and I assisted Judge Nangle with the reviewing the evidence and handling the case and drafting the opinion that was ultimately approved by the Supreme Court.
Thank you. Could you give a brief description of the role of a law clerk in the courts?
Okay. It varies from judge to judge, but I can tell you that Judge Nangle required his law clerks to serve for 2 years, and he used to joke that the first year was for the clerk, gain all that experience, and the second year was for him, meaning you were efficient and productive by that second year, and moving, like a well-oiled machine. But the job of the law clerk was basically to do a lot of the background work on cases and get them developed and worked up. There always is, whether it's civil litigation or criminal, there's motions that are preceding a trial, and those motions have to be ruled on. The parties brief them, the law clerk reads them, summarizes the briefs for the judge, proposes a resolution, judge tweaks that, and if he agrees with it, and then ultimately orders are issued. And so the law clerk drafts and writes those orders for the judge to sign. In criminal cases, our involvement was mainly limited to pretrial motions. There wasn't much role for a law clerk in a criminal trial. But in a civil trial, especially a non-jury civil trial, then you sat in court and took notes on the evidence because the judge was the fact finder, and you assisted the judge with recalling the evidence and finding the facts.
Thank you. Could you give a description of your role personally in Cathy Kuhlmeier v. Hazelwood?
Well, it was a non-jury civil case, so I sat in. Even before the case went to trial, there was rounds of pretrial motions, and so I assisted in reviewing those, reading the law that the parties had cited, summarizing that for the judge, recommending disposition, drafting orders, and all of that ultimately led in the process. A civil case is a lot like a moving train, so it's got stops along the way to its final destination, and it's constantly moving. And so the job of the law clerk is to keep that in motion so that we have justice being meted out fast and fairly, because there's a large number of cases. But in the Kuhlmeier case, once it finally got to trial, then I sat in on the pretrial meetings and then the actual receipt of the evidence. I think I sat in the jury box because there was no jury, and took notes to supplement the judge's notes. We discussed the evidence presented at the end of each day. And then at the end of the case, there were closing arguments, and we evaluated those. The judge made a preliminary indication to me of how he wanted to rule based on the issues. We waited for the parties' briefs, proposed findings of fact, proposed conclusions of law. Both sides submits them. There's usually some research, reading cases that they cite in support of that, and there was certainly a fair amount of that in this case. And so then I worked with those, drafted an opinion that I think did what the court wanted to accomplish, and that was consistent with the evidence and the facts. And ultimately, he would modify that as he saw fit, and then ultimately it was his signature. He issued it as a judge.
Thank you. Do you have any memories or particular thoughts that popped out to you from that case?
Well, I do have. I have a memory of the witnesses testifying, both from the administration and from the student standpoint. I think the ultimate issue, as we all kind of knew going in, is whether or not they could establish that this paper was created as a public forum for full and free expression, unlimited expression, within the confines of the high school newspaper venue. But I think I recall, being not convinced that it was a public forum, that there was sufficient evidence on the part of the teachers and the administration that they had made it clear, that this was a part of curriculum. Students knew that going in. They weren't fooled in the sense that they were led to believe it was a public forum, and it turns out it was not, so they weren't tricked or anything. And that there were some sensitivities beyond the First Amendment issues in the case that were not fully taken into account or taken seriously by the student journalists. Things having to do with parents' privacy, parents' rights. I think there was an article about divorce. I think that there was clearly some possibility of identifying and perhaps embarrassing those parents. So, their interests were at stake, other privacy interests were at stake, as opposed to, and having those be injected into a curriculum-based environment. The school had a right to protect itself from that kind of blowback from them, if there was any.
Thank you. I'm going to pass the mic on to Lily.
Okay.
All right. Can you talk to me about Judge Nangel's decision-making process for reaching his opinion? And if you had any difficulties along the way?
In general, he kept good notes during proceedings in court as a general matter. I would be there to take notes on the cases that were assigned to me. He always had 2 law clerks at any one time. This case was assigned to me. Other cases were assigned to the other clerk, and so it's just a matter of happenstance and luck that this one was assigned to me. But he would review his notes, and a lot of it is, he asked his own questions sometimes in court as well, as most judges have a right to do. And so if he had any question, particularly in a non-jury case, he would ask them. And then that would shed some light on sort of what he was struggling with from a factual standpoint. And we would then talk about those perceptions and those conclusions based upon the performance of the witnesses. There's a lot that goes into that, such as credibility and whether or not the questions made sense, the answers made sense, whether they were consistent with other evidence, was there internal inconsistencies, was there external inconsistencies, was there impeaching evidence. If there, a lot of times, one witness sees things and remembers things one way, another witness another way, who's more credible? In a trial, that's always a give and take. And so we would discuss those things, and he was usually had no difficulty expressing his view of who he thought was credible, and was confident in his conclusions in that regard. But I personally had no issues with this decision-making process. I learned it early on, followed it, believed in it, thought it was appropriate. We certainly moved cases. He certainly cared a great deal personally about doing the right thing in every case. And that's something that he passed on to me in my career. And so I think that's a good description of his decision-making process.
Thank you. That's all for me.
Okay.
I'm Henry Rosenzweig.
Hi.
What is it?
Put the video.
Here. It's too interesting. Great. Thank you. My question for you, or one of my questions for you, is what is your opinion on the eventual outcome of the case, and was there any part of the case that you felt was particularly strong, whether in favor of the students or in favor of the school district?
My opinion of the case was that we reached the right result under the evidence and the facts and the law in the case. I don't think we would have. I don't think Judge Nagel would have signed his name to the opinion in the order if he didn't think so. There was never an occasion that I can remember where I disagreed with him. I felt free to express my views to him, and he wanted my candor, and he wanted to hear it. He didn't want a yes man. But in this case, I think that we both looked at the evidence and felt that the school district had a stronger case on the issue. The central issue was whether or not the particular newspaper in question was created as a public forum for student expression. And there was plenty of evidence to suggest otherwise. The students had to ignore that evidence to come to their belief, as they expressed that they thought it was a public forum, that they could do whatever they wanted to do in it, and have the paper paid for and supported and bear the name of and be associated with the school district. It wasn't as if this was a privately student-run newspaper, kind of an underground version, a student version of the Riverfront Times or something that was being done. Then it would have been a different case. Then it's like, well, what's the authority of the school district to quash students' free expression outside of the environment of the school? Within the environment of the school, that's where their prerogative was. And I think that was the conflict and the difficulty that the students had in accepting that they, in fact, had to yield to some element of administration and curriculum control as exercised by the teachers. So that's, I felt, was the strongest part of the case and ultimately what carried the day.
Thank you. My next question is, did this case feel any different than any other case that you or Judge Nangle had in your tenure? And did either you or the judge feel that it was particularly significant when compared to other cases that you had worked during your time clerking there?
First of all, he as any district judge, not just him, but every district judge handles a large volume of very significant cases all the time. My subsequent 40 years of practice in federal courts only reinforced that to me. But the thing about district judges, they don't get to pick their cases. They get whatever's brought to them, whatever comes to them on the wheel, the assignment wheel. And so this was unique, I guess. The only thing unique about this case is a case that wasn't about money. It was about damages. There was nobody who was hurt. There was no federal statute that was involved that was trying to be enforced. There was a constitutional claim that a constitutional right had been violated. And the reason we were there is because the Constitution limits state action. The First Amendment is not a right of expression that, a private person can chill your right to expression. And the Constitution doesn't say anything about that. It's what it says about what government does. The public district is government. And so we're here actually dealing with an issue where whether something the government did violated a constitutionally guaranteed right. And so that's a little bit of a unique setting. It wasn't an everyday case. We didn't hear constitutional cases on an everyday basis. More often we heard rights being asserted in the context of either prisoner litigation and diversity of jurisdiction cases, contract cases, other sorts of things that came to the federal courts. So I don't think anyone had any sense at the time that, this was a case that was going to go to the Supreme Court, or that 40 years later someone might actually be thinking that it was important to record some audio tape statements about, okay? It was a case, I think we recognized it was an important decision. We expected to be vindicated on appeal. We were surprised when it wasn't. And then ultimately when the court granted cert, and I believe the court granted cert on this. I don't think there was an automatic right of Supreme Court review. And felt fairly confident that it would prevail. Well, I'd say the one surprise came from the Supreme Court, and that was the extent to which they complemented, tracked, and reinforced the decision that Judge Nangle had rendered. Usually by the time you get to the Supreme Court, nobody cares who the district judge was. There's a kind of a sort of a minimal rule, but Judge Nangle was not unknown to the Supreme Court. He was very well known to Justice Rehnquist, and it seems as though the court went out of its way to compliment his work in the original case and in affirming his decision.
Wonderful. Thank you. I'm going to pass it off to Ruthie.
Okay.
This is the last couple of questions. Thank you so much.
Great. Okay, we saved the toughest questioner for last.
I'm Ruthie. Just to introduce myself, how are you today?
Good. How are you?
Good. I think earlier I missed a brief introduction just of yourself, so would you mind doing that real quick?
Well, I'm born and raised in St. Louis. Went to St. Louis University. Came from North County area. Went to St. Louis University, and then went to law school at Washington University. I graduated in '83, and amongst the jobs that I was pursuing was a judicial clerkship, and I was extended an offer by Judge Nangle, and I accepted. He was chief judge of the Eastern District of Missouri at the time, and I clerked for him for 2 years, and he is instrumental in getting me my next job, which was with the U.S. Attorney's Office, where I served for almost 30 years, as half the time as a supervisor, and throughout that time handled something like 40-plus lengthy jury trials and appeals that went with those. And then in 2013, I left the U.S. Attorney's Office and I went into private practice ultimately with a firm called Hush Blackwell, where I am now. And my specialty has been intellectual property litigation, most of all of which takes place in federal court, which is what I know. And then also I do a little bit of white-collar criminal defense, based on partly because of my background. So.
Okay. Moving on to the question. So what were your and Judge Nangle's experiences like following the court case?
Following the Supreme Court's decision or following the end of the case? Once the ruling was issued in this case and it was a final order, it was appealed to the Eighth Circuit. It left our hands. It literally left our hands. The file goes to the Eighth Circuit. And I can tell you that the morning after the Kuhlmeier case tried, we were off onto another one, probably that afternoon. There's still nothing stops in the trains that are moving all the time. So you always have to be like having your eye on what's the next priority, what's the next thing, what's been sitting around for too long that we need to get moving. And the judge ran a very tight ship in terms of keeping a docket moving. That's not an easy thing to do, as you might be able to tell by some of the progress of some of the cases these days. But I'd say nothing changed. Certainly, we talked about when the Eighth Circuit reversed the decision, poured over the opinion, felt it was wrongly decided. We're happy to see the Supreme Court take it up, and then I know he was personally pleased when he saw that his decision had been upheld by the Supreme Court. Particularly there's large passages of the actual order that I helped draft and that he wrote and that he signed that are quoted in the opinion of the Supreme Court. That's, in my experience, that's not common. So I think that made him feel somewhat proud that he had gotten it right.
What about yourself? How did it feel to see that in the Supreme Court's opinion?
I would say, I was pleased. Probably, it's not the same as perhaps getting a verdict in your favor after you've been in trial for 3 or 4 months in federal court, but it's not the same sort of elation. But I was pleased, and I think we always felt that we'd made the right decision, and that doesn't necessarily mean the Supreme Court's going to get it right, but we felt like they got it right, so we were right all along, and that felt good.
Is there any final thoughts or comments you would like to add?
As a case, it I guess it holds interest, particularly amongst young people, because it's a case that has within its context rights that everyone thinks they have. Okay, and one of the things as I've practiced law and so forth is like, we're not always as free as we think we are in the United States. There are limitations on all of our rights, and that's part of ordered government. And so the mere fact by just saying, oh, this involves the free expression rights of students, that doesn't end the issue. But a lot of people wanted it, I think, to say because it involved that sort of emotional or provocative issue that should be the end of it. No, there's another side to it. And the other side is whether or not, was it a public forum or was it a part of curriculum which you can't deny the Board of Education the right to control. And so that's why I think that, you need to approach it. You need to approach the case with a complete context in mind and not have blinders on that, oh, this is whatever you think about it, you think, well, this is a terrible result because of limited free speech rights of students, et cetera, et cetera. That's not really what it does. What it does is it says in the context of a school-based curriculum run newspaper, the school has certain rights to limit at certain times. Doesn't mean it's complete. It doesn't mean that it's completely censored the students, but it's got a right to protect its interests as well. So there's a balance all the time, and that's what the law is always trying to do is achieve that balance.
Well, thank you so much for your time today. We really appreciate this interview.
Okay.